Are you ready for some wild excuses? Well, buckle up, kids. You're leaving the ordinary and entering the court gallery. Well, kids, it's Tuesday night. It's been an interesting day in court. The dogs are on the arms of the couch because they are as excited as I am to present to you three amazing judges from the courts of Michigan today. We're going to start the night off with Judge McNally. We're spending about an hour with him with a wide assortment of cases from Judge McNally's room. We call him Judge Dad for a reason. We're going to reaffirm that reason tonight. And then we're going to Judge DeSanto. I'd like to say it was a normal, average, everyday. Well, what am I saying? Well, it's normal, average, and everyday for Judge DeSanto. Every day is crazy in her courtroom. We're going to see what happened today. Then we're going to check in with Judge Simpson, who had a real fun moment at kind of the beginning of his docket. And then we finish things off in the most rude, unexpected way. It's landlord-tenant day in Judge Simpson's courtroom, and you know how those go. Sometimes they're good, sometimes they're just sad. No matter how they go, it all starts right now.
Leslie Bolzager versus Cynthia Hernandez, 2504922.
Right here, man. Yeah, the phone.
Boy, you didn't do a very good job on this, ma'am. You can't be doing this. Your name?
Leslie Bolzager.
Your name.
Cynthia Hernandez.
Why don't you come up here? I want you guys to resolve this. Did you buy a car from her?
Yes.
Did you
It's
stop
paid
making?
for. I
Hang
have the
on,
title.
hang on. Did you stop making the payments?
No, the car is paid for in full.
Is that true? Did she pay for it in full?
No, Your Honor. In the contract, it states,
Do you have a security agreement? I didn't sign a, did I sign a, I was concerned about this. You didn't have a security agreement, did you?
no, but my name was supposed to be on the title.
You guys, you try to be your own lawyers. It'd be like me. I don't care if she was your friend, not your friend. You guys you can't do things like this. This was a recipe for a disaster. Your name's supposed to be on the title of somebody else. When they're driving, you don't know if it's insured. They get in an accident, you get sued. You probably aren't going to have insurance on it. They're going to be coming after you. Ms. Hernandez,
Yes.
did she pay the payments?
No,
Good. Then
it was
you,
the last payment to be made on March 1st.
well, what if she paid in advance? Did she pay in advance?
Two $500 payments.
Did you pay more than two $500 payments, Ms. Hernandez? Don't lie to me, because I'm going to get to the bottom of this. Listen to me
Yes,
very
I
quickly.
paid two on the day at the Secretary of
I
State.
didn't ask you that. Hang on a second. I want to be clear.
Okay.
I don't want anybody lying to me. And I'm going to find out who's lying. If she's saying it's not paid and you're saying it is paid, one of you are lying to me. So if you want to come up here with all your documentation and I'll try to resolve this for you guys right now, that would be fantastic.
On September 12th.
Hang on. I didn't say that. I didn't say anything here. Why don't you get dressed and come on up here? You live on Riverside, right?
Yes.
It's only a 6-8 minute drive at best. Bring all your documentation that tells me that you've paid for the car. How much do you think is owed?
2,000
How did she pay on the first 2 payments?
cash.
Nice.
Right.
Really good.
We were
Really?
together. She was living in my house.
Really, really, really good.
Yeah.
Did you give her a receipt?
Well, I wrote
Did
it
you
in-
give her a receipt?
I wrote it in this book.
Did you give her a receipt?
No, you're
You
on.
guys, you know what? I mean, bring all your documentation up here right now, Ms. Hernandez. So you guys, she was supposed to put your name, keep your name on the title, huh? Did you sign did you sign the title over?
I didn't.
Why did you sign the title over before you? It'd be like you tell me you're gonna buy my house and I sign, hang on, blah. Well, then you should have talked to a lawyer. That's what they do.
Right.
That's what they do. I never sold it before. Come on up here, Ms. Hernandez. We're resolving this morning. Get yourself dressed. She's going to wait and you come on up here. How long will it take you?
Say, I don't know, 40 minutes.
I'll see you about 10 o'clock. Don't hurry. Don't rush. I don't want you getting in an accident.
Right,
Take
right.
your time.
Okay.
I hope you're never going to do something like this again.
Absolutely not.
Oh,
It's unfortunate.
this pains me to see this. It really does. I know it's only $2,000, but $2,000 is a lot of money. Bring all your documentation that shows me she paid you. You paid her. If you took cash out, you can go to the bank.
I had
Wait.
cash. I don't.
Wait,
I
ma'am, Ms. Hernandez, I'm going to find out who's lying to me. It doesn't matter to me who's lying. I'm going to, ma'am,
With that too.
ma'am. I'm going to find out who's lying. You guys just make this hard when you do this, like with a handshake.
I made a mistake.
You didn't make a mistake. You don't have to apologize to me. You might be out when it's your burden of proof here. But I can tell somebody's lying, and I'm going to tell you who it is when we get here. Bring all your documentation, Ms. Hernandez, okay? That tells me
Okay.
that you paid this. Guys, I mean, you say you have a security, you filed a pleading saying you have a security agreement. Do you know what a security agreement is?
I was going by what
The
the
bank-
lawyer told me to write down.
Don't tell me what the lawyer told you. That's between you two. If I went to a bank or I went to a dealership and bought a car, that's when I will execute a security agreement. I doubt that you had her execute a security agreement.
No.
Why'd you allege it in the complaint? Shh. Give me all your documentation. Did you ever sign a note at least?
We had this agreement that I gave you a copy. You should have a copy of our contract.
Okay.
And she signed for the 2 payments that she did give me.
She signed?
She signed, yeah. The 2 payments, one on,
Oh, man, that's kind of telling, Ms. Hernandez.
and it says in the
You
contract.
guys come up here. Come on, get dressed. Come on up here. But I'm telling you, I'm going to have you guys under oath and I'm going to resolve this today. And you guys are going to, you're going to be honest with me because I'm going to find out who's lying to me. Okay? I'll see you whenever you get here, Ms. Hernandez. Unless
Okay.
it's really, Unless you guys want me to adjourn this for a week or so, I'll be happy to do that.
Well, I'm volunteering today where I live.
Where do you live on Riverside? What do you mean you're
Yeah.
volunteering?
At the towers where I live.
Ms. Hernandez,
Yes.
why don't I do this? What do I have tomorrow, Jennifer?
Tomorrow is the 11th. You have Brownstown and Groseal reps. So let me see.
It's easy. All right, 8:30 in the morning. Can you be here tomorrow, Ms. Hernandez?
Yes.
Can you be here tomorrow at 8:30?
Yes.
We're starting at 8:30. Do I have sentencings on that docket tomorrow?
No, I don't see any sentencings at
Good.
8:30.
Perfect. 8:30. You guys be here. Don't make me wait. All right? I'm gonna
Okay.
adjourn. We'll set for February 11th at 8:30. Everybody's to bring any and all documentation. I'm gonna figure this out tomorrow. Have a good day.
Thank you, Your
Thank
Honor.
you. Thank you. Michael Mwathi versus Carlos Medina Cardina.
Right to the podium.
Your name?
Michael Malati.
Your name?
Carlos Medina.
You were gonna get a contract.
Yes.
Is he here?
Zoom.
Good.
He was
Good.
on Zoom, but he's no longer on Zoom.
You're gonna have to go call him or something, okay? Go call him and I'll go from there. All right, why don't you have a seat? Rick, you can have a seat right at the table there if you'd like, sir. Do I have, what's the next one?
So.
Stone versus Chavez. Anthony Stone versus Rena Chavez. 2504928.
Right to the podium.
Is Rena Chavez here?
Yes.
I've not had her check in with us, Your Honor.
All right, your name?
Anthony Stone.
Good morning. This was scheduled for 10 o'clock, so we've got plenty of 15 minutes, so to speak. Raise your right hand. You solemnly swear affirm and penalties of perjury that the testimony you will give in these proceedings will be the whole truth self you got. You say failure to pay, repay personal loan and property damage. You can put your hand down. How much did you
Your
loan
Honor,
her?
if I may, she just walked in and just checked in at the civil window. She's on her way down.
Your Honor, I have some evidence here for her. I was told to give her.
Just wait a second. Let me.
Good.
I don't want anybody to rush.
Yeah.
She's 40 minutes late. Bad enough I have to wait for lawyers. Come on up here, Miss Chavez. You're late. Where's Rena Chavez at?
It's-
Is she down? Is she on her way or did she walk around the block first?
I don't know, Your Honor. She was at the window. We told her to come to courtroom
Rena
3.
Chavez, I need her in the courtroom. She's apparently out there.
Sir,
She's
in there.
Is Rena Chavez here?
She's not in our courtroom.
Rena Chavez here?
Yeah.
What are you doing in there?
Oh, I thought I was waiting for someone or talk to someone.
Come to the podium, man.
Okay.
Be careful. Why are you late?
I've had some emergency, I've had a, brakes, there's something wrong with my brakes right now with my car, so that's why I'm late today.
Tell me your name.
My name is Rena Chavez.
If you two want to talk, try to talk this out. Do you two know each other? Of course, if you gave it. I see. Do you two want to try to talk this out, or is that impossible at this point?
Very impossible.
Okay. All right. He claims that you failed to repay a personal loan and property damage. I'm going to go ahead and I'm going to ask you both. If you proceed in the small claims division, you have to give up certain rights. You don't have to give up those rights. But if you proceed in small claims, you're giving up rights. If you want to have the case removed to the general civil division, you can hire a lawyer if you want to. You can have a jury trial if you want to. You can appeal my decision if you don't like it. To the extent that you are entitled to a plaintiff, you can seek in excess of $7,000. If you waive those rights, we're going to stay here, in which case you can't hire a lawyer, can't have a jury trial, can't appeal my decision. Do you understand that, Mr. Stone?
Mhm.
Yes?
Yes.
You have to keep your voice up.
Yes.
Do you understand what I just said, Ms. Chavez?
Yes,
Do you wish to give up those rights and proceed here or have the case removed? Mr. Stone,
I'd like to proceed here.
you waive those rights?
Yes, sir.
Ms. Chavez,
yes.
you waive those rights? Do you have any other witnesses, Mr. Stone?
Oh, my parents can vouch for it, but I.
Wait a minute, are they here?
No witnesses.
Okay. Do you have any other witnesses?
Oh, I don't even hear.
Pardon?
I don't have any witnesses.
Raise your right hands. Raise your right hands. You gotta raise your right hand again. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Mr. Stone?
Yes, sir.
Ms. Chavez?
Correct.
Okay. You can put your hand down. How does she owe you this money?
Oh, I lent it to her.
All right, you gotta be more specific. How long did you two go out?
For a year.
Tell me the dates.
This was summer 2024 up until summer of 2025.
Is that true, sir?
Yes.
All right. When did you loan her the money?
January through
January of what?
January 2nd, 2025.
Do you have let me see the note you had her sign.
It was a verbal agreement.
Verbal agreement.
Yeah.
How'd you loan her the money?
Just Venmo, you know what I mean?
You Venmo'd her?
Yeah.
Do you have your Venmo records?
For particular loans I do, but it was just the verbal agreement and I was paying utilities, her 1/4 of the utilities in the household that we lived in. And I have bills I printed out and gave to the court, month by month.
I need those, Jen. Wait a minute. So all the money you loaned her was by Venmo?
No, I just paid on her behalf with the understanding that she would pay her share.
Hang on. Wait a minute.
Your Honor.
Who was living in
Say
the,
something?
not yet. Who was living in the house?
My father, my mother, myself, and me.
So is that true?
That's correct.
So was it your responsibility to pay 1/4 of the utility bills?
I never assigned a contract.
I didn't ask you that.
Yeah.
Did
but
you agree to pay
Yes.
1/4 of the utility bills? And did you pay
just
one?
verbal- Some payment,
It's fine. Did you pay 1/4 of the utility bills?
some months, yes.
Or do you acknowledge that you did not pay your fair share of 1/4 of the bills?
I would say, but because I'm not working full-time and I'm a full-time grad student, so that's why.
Okay, how much do you owe him?
He made, so he wrote me a letter.
Let's slow down. Let's slow down.
Over $2,000.
Slow down. Slow down. Did you tell her the amount?
There was a demand letter sent in September, and I haven't received any payment.
I know. Did you tell her the amount that she owes you?
In the demand letter, it showed that, Your Honor.
Yeah. Do you have the demand letter or did you file it?
Yeah, it should be in the file.
So we do everything by M filing now. That's why I asked. Do
Yeah,
you know the amount?
it's 2,228.58
Did you dispute that amount when you got the email?
What do you mean dispute?
Well, did you write him back and say, I don't owe you that much, I owe less than that, or I owe half of that?
I tried to call him, but there was never,
Do you owe him 2,228.57?
he claims that I did.
I didn't
Yes.
ask you what he claims. I want to know what you think. Do you owe him 2,228.57?
I don't believe so.
How much do you owe him?
I think maybe close
Well,
to the two.
now wait, I wanna just, I say this often, it's so true, that the greatest thing about math is there's only one right answer, and it's right to the pen. There's no room for discussion. So if you're gonna tell me about $2,000, I would really like you to sit down, and I would like you to figure out to the penny, as he did. He said you owed 22857, how much you owe. Is that fair?
It doesn't sound like it's fair to me since he did add.
No. Wait a minute. What I was trying to say to you, is it fair for me to ask you to sit down and figure out exactly how much you owe him?
Yeah, it's fair. I can sit down and track down how much I owe him.
Now, you also said property damage.
Yeah.
What kind of property damage?
It was to a TV I had. She had returned it. She took it originally when she moved out of the house, thinking it was hers. After some discussion, we discovered it was my television. She was in the midst of moving in her vehicle. The TV was up against the headboard and it was cracked, upon receiving it back. So, I said, hey.
When did you buy that TV?
It was given to me from a family member,
Alright.
handed down.
Any idea what the value of the TV was?
I looked on Marketplace, Your Honor, Facebook Marketplace. I said $50. I think that was fair. It's used. It
Right.
might be a smart TV, but I think with the controller missing and
Is
the,
$50, is that what happened with that TV?
Yeah, that's correct, sir.
All right, so do you think $50 is fair?
That's fair.
All right, so you guys are only $258 apart, it sounds like. You said about 2,000. And he said 2258.57 plus the 50.
the 50's included in that, Your Honor.
I see.
Yeah, it's all, it should be on the first page.
So if you thought 2,000 just for the loan and $50 for the TV's fair, you guys are only about $178 apart.
Yeah, because on the letter, it said that he made payments to the court to get this hearing, so he wants me to pay for that.
Well, he does get to recover that.
Your Honor, I should say for the record, the demand letter was off a little. I rushed it a little. I wanted this off my back. That's the truth. I went back to make sure, the utility bills were right. Well, I looked at the service dates, and for DTE, for example, it's the middle of the month to the middle of the month. It's not just January, for example. So I did all kinds of prorating. I did all kinds of math, and then I came up with some months that are actually less than were discussed.
Did you still come out to the total of 2228.57?
Yeah, and then there were two other loans I remembered that added to that original 2,000 and some change that was in the original demand letter. That's why it's a little bit higher today. There was she went to Minnesota. She needed I was for her clinical placement in Minnesota for her physical therapy school. I loaned her some money for room and board for the few days. And that should be all in there. I got the Venmo picture of that, and then also.
Okay, let's slow down.
Yeah.
Let's slow down. What exact amount do you think she owes you now, including the TV?
2002
2857?
58. It's on there.
222857.
57, 58. It's 58 on the paper.
Okay,
Yep.
2028.58.
Yes.
And you said he owed you you owed him about 2,000. You want to go back and you want to look, and right now I can give you some time. You can go sit down and say, I think this is too high. It sounds like he did his homework though.
Okay.
If you want to agree to that, I'll be glad to enter a judgment. We'll set up a payment plan and you guys can be on with your lives. If you don't, tell me, I'll give you some time. You go in the back room there and you can do your figures.
I mean, I like to think that he's saying this is correct with the amount, so and I see it on here too. I mean, I'm fine with making like I said, I'm a grad student.
Okay, I get it, but let's take one thing at a time. Ma'am, I get it. But ma'am, we'll cover that. Nobody wants you to not be able to eat, I promise you. But, so you agree, you don't want to go back and refigure anything, right? So you got 222858 plus, you got a filing fee here of 70 and a certified copy of 1888 more dollars, true?
True.
Do you have any other out of pocket?
No, nothing. I printed out a lot of papers. I don't even care about that. Nope. Made some copies, but
So my math, it comes out to 231658. Is that true?
yes.
All right. Now, ma'am, you're still under oath. Are you working at all?
I am working, yes.
How much do you make?
I make $20 an hour.
How many hours do you work?
I work 20 hours a week, but that's for school. I could be working less a week because full-time.
Tell me how much you think you can afford to pay weekly, bi-weekly, or a month.
Honestly, sir, I am in a transition phase of my life. I could only afford him to pay him $100 bi-weekly. That's with my,
Okay.
like, check.
You're good with that?
I don't want that much, Your Honor. I know she's in a tough spot. I still care for her as a person. I'll be $50 a
That's
month.
great.
But she's saying bi-weekly.
Okay, so yeah, 50 a week, sure. Yeah.
Wait a minute. Bi-weekly meaning every other week.
Right, that would still be.
She said she could pay 100 bi-weekly. You're saying you don't want that much. What are you gonna ask me to have
Is
her?
that a stretch for you?
I mean, I can, what works, I can do 50 bi-weekly, I can do,
50 bi-weekly.
When would you like to start?
I would like to start in the last week of February, once I have my first.
Okay, so that would be like February 27th. Does that work for you?
That works great.
Is that good with you?
Yes.
How easy this was? All right. Where are you going? What are you studying?
Become a physical therapist.
Good for you. Good luck. What do you do?
Thank you.
I'm a behavior technician. I work with autism.
Good for you. Good luck to both of you.
Thank
I'm
you.
filling out the judgment and you're all set. Thank you very much.
Thank
You can go down the hall and get a copy of it. Thanks. Good luck to you both.
Thank you. What's my next steps, Your Honor?
She's gonna pay you that.
Okay.
You,
Court handles it?
well, no. She's gonna pay you directly.
Okay.
And now if she doesn't pay, you can move to set aside the installment payment order. You could still, I'm just telling you, you could still, garnish not bank accounts and tax returns, but doesn't sound like you're gonna do that. So as long as she stays with the payment plan, there's nothing left. She's gonna pay you direct. You're gonna pay him direct, right?
Yes.
Have a paper trip, no cash, checks, okay? Thank you.
Appreciate it.
Thank you. Good luck. Go down the hall, both of you, get a copy of this. Michael Mawafi versus Carlos Medina Cartagena, 2504545. All right. I know I covered this with you before. Mr. McQuithy, I'm going to ask you to take your hat off. Your name again, sir.
Michael Milwaukee?
Your name again, sir. So you both understand, I don't think I covered this with you. I might have before. Can you turn that podium toward me a little bit better? It swivels. There you go. A little bit more. Thank you. If you proceed in the small claims division, you're giving up certain rights. You're giving up the right to appeal my decision, to hire a lawyer, to demand a trial by jury, to collect in excess of $7,000 to the extent that you're entitled to it. If you waive those rights, you're going to stay here. If you want to exercise any one of those rights, just tell me. I'll remove the case to the general civil division, in which case you can hire a lawyer, demand a trial by jury, collect in excess of $7,000 if you're entitled to it, and appeal my decision if you don't like it. You understand everything I just said, Mr. Milwaukee?
Yes.
You understand everything I just said, Mr. Medina Cartagena?
Yes.
Do you wish to give up those rights and proceed here, or do you wish to have the case removed? Mr. Milwaukee?
Proceed.
Mr. Medina Cartagena?
Proceed.
You waive those rights?
Yes.
You waive those rights? Yes. Mr. McQuithy, your name?
Kirk McQuithy?
Is he your witness?
The kind
That's what I mean. I'm going to ask all of you to raise your right hands. Mr. McQuithy, I need to see your right hand, please. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth. So help you God. Mr. Milwaukee,
Yes.
Mr. Medina Cartagena,
Yes.
Mr. McQuithy.
I do.
All right. Have a seat, or you guys can stay there. Just tell me what happened now. You brought the contractor. It says defendant was hired contractor to renovate 2 bathrooms, raise an existing vanity and paint it white for both bathrooms. He was paid through Zelle, $8,000, has since abandoned the project. I sent a demand letter wanting to resolve this matter out of court. However, defendants continued to ignore my attempts to resolve the issue. Did he pay you $8,000?
Yes.
What kind of work did you agree to perform for $8,000?
There's 2 bathrooms, the guest bathroom and the guest bathroom and the master bathroom shower.
So you were doing 3 bathrooms.
No, we first agreed with 3 bathrooms, but then it changed because they didn't want to do the basement.
Wait a minute, you did 2 guest bathrooms.
No. One guest, I didn't do the guest bathroom yet, but we agreed to do 1 guest bathroom and the master bathroom.
1 guest bathroom and the master, or just the master shower? Did you guys have any contract?
We had a estimate that I sent them an invoice.
Let me see the estimate.
I think we gave it to you.
Okay.
last time.
Okay,
And through the invoice.
so it looks like all right. Did he do the guest bathroom?
He did not.
Did you do the guest bathroom?
I didn't get to start it, no.
Did you do the master bathroom?
The master shower, yes.
And
Your Honor,
yes,
he did, but he did not complete. He started, did not complete. I agree.
I sent pictures, to the court there.
do we have the pictures, Jen? I'm so sorry.
Who sent the, who sent the pictures in?
Mr. Defendant,
Just said
Where did he
see you
send them?
To the court, email, Jen.
When did
Jen?
you send those, sir?
I sent them today, this morning, once I got here.
I haven't checked my email, Your Honor, because we've been on the bench, so. Oh, he sent them at 9:58, so I've not even opened it. I'll get them printed.
so I just want to make sure I understand. The only work you did was on the master bathroom.
Yes.
Did you complete it?
Completed the shower, yeah.
Was that all the work you were supposed to do in the master
The
bathroom?
only thing left was the shower door that was ordered after. And when he ordered it, it took about like a week, so
So
I
the shower door was not
was
installed.
not installed.
You completed the master bath shower,
Yes, sir.
and you did not do,
And I bought all
wait a
the,
minute, slow down. You did nothing in the guest room.
no, didn't start.
All right, good enough. How much did you pay for materials?
I sent the receipts to her, about roughly 1,700 plus the $300 of,
Did you just send those this morning too?
yeah, send it all to me. But it was the first 2,000 that he sent me was for the materials because he said he didn't have a chance to buy it. So I made him a favor. It's not part of the contract or the invoice. He said he couldn't buy the material, so I did the favor to buy it for him. The first 2,000 was to purchase the materials, which he has in his garage right now.
All right.
All of that.
So you spent $2,000 in materials, you did the master bath shower, you didn't do the guest room, and you didn't install the shower door, correct?
Yeah.
And do you dispute his statement that he spent $2,000 in materials? At least did he provide you with invoices to that effect?
He did not.
And you just said you sent him this morning?
Send them all the receipt from Home Depot, everything I spent from the shop, to the bathrooms, to both bathrooms.
So after you did the master bath, and I'm sorry, Mr. McQuithy, I am going to have some questions for you. After
Yes, sir.
you did the master bath shower,
Mhm.
why did you leave the project?
It only took like about 2 to 3 days, a week. The first couple of days that I didn't show up, I texted him. I've been texting him all the time, and I texted him I wasn't feeling good for the first couple of days. And then I told him order the shower door, and then he called me. He says it's gonna take like about a week. So during that week, I started working in another project, and then I was gonna get back to him. I never told him I was not gonna come back. And then he sent me a letter demanding after 2 weeks. It wasn't even a month passed by. So he sent me letters after 2 weeks and just kind of harassing me.
All right, let's slow down here.
Gonna take me to court. So that kind of took my energy down.
When did you start working on the project?
It was end of September
It's September 26th.
9.
September 26th, September 29th. Okay, do you agree with that?
26th.
All right, one says the 26th, one says the 29th. And what days did you work on the project to complete the work that you described that you completed?
That full week.
So you're saying you worked there until, I don't know, maybe till about October 5th or 6th?
Probably a little bit more than that.
How many days was he there?
In total, he was in my house probably about 3 days.
No. You took I'm sorry. He made an oath. You can't lie. You can't.
How many days do you think you were there?
I was there the full week. I was there the whole week between me and my workers. We was there for the whole week. I had a plumber because we had to remove the plumbing. We had to remove a vent that was in the middle of the wall, which I didn't charge them extra for that either, for removing an extra vent.
Can I ask you a question? They gave me some invoices here. One says bathrooms, date ordered September 16, order total 1252.77. Another one says purchase September 17, $75, 375 item quantity 20. Another says $300. That looks like a payment.
That's the trash pickup that I paid for. That's part of it.
Then you got another one here for $167.52.
Those are extra materials that I had to buy.
And all the materials are in his house?
Yes, well, the second bathroom as well was in the house.
When did you inform him you didn't want him back there?
Your Honor, I did that. What happened was he started the project well. He got in the house, the bathroom, started the work. And I remember he sent his guy, I can't remember, it was a Friday. They came and worked until 10 p.m. And I was okay with that. After that, I had to buy the shower door. I did order the shower door. I told him, they told me it might take a week. And he said, let him know when the door came. So the door came, I texted him. He said he was gonna come. Then he told me he was sick. And I said, man, just let me know when you feel better.
Well, from the time that you got the door,
Right.
that it arrived at your residence.
Yeah.
You notified him, he said he was sick.
Yeah.
Did he ever come back to the property?
Never came back.
What day did you tell him, I have the door, I've received the door?
I have to check on my text, but it was probably a week, September 26th, probably before the 10th of October.
Okay. And when did you make up your mind? So after you called him, he never came back?
He never came back.
Did you call him again?
Yep, I was calling, and he kept telling me he's gonna come, he's gonna come. So what I did, I sent him a demand letter, giving him 10 days.
When was that? And do you have a copy of that letter with you?
Yes,
What is the date?
10/15/25.
Did he send you that letter?
Yeah.
Did you go back there within 10 days?
No, I called him.
And what'd you say?
I spoke to him and kind of scheduled to go back. But he was threatening me to take me to court, so my energy just kind of, if he's not taking me to court, just take me to court. Because it was not feeling good going back after all the threats of taking me to court, so. I'm here, I'm not here because I don't want to pay him, you know, I'm here because he wrote in the letter that he gave me 8,000 and I never, you know, like I suddenly disappeared. That's what he wrote. I'm not here because I don't want to pay him. We can make an agreement of payment. That's fine with me. I even text him, I could reimburse you for the other bathroom. He knows that. And he said, that's absurd. You don't have to do that. I text him to reimburse him. I'm here because in this letter it says, I paid him $8,000 and I haven't seen him ever since. So in other words, he paid me and I left. I did work there. So, you know, I feel bad because he's saying that he paid me, in other words, and I never showed up. The letter that he sent me, he's accusing me of scam by the law of Michigan. That's what so it doesn't feel right.
Okay,
Yeah.
let me ask you a question. Mr. McQuithy, you're under oath.
Yes, sir.
Is the shower door installed yet in that bathroom?
As of Saturday, Your Honor, no.
Did you go and look at the property? You did, didn't you?
I did, Your Honor.
Well, how much would it cost if the plaintiff, Mr. Mawarthy, was going to hire you? And just in labor, how much would it cost for you to do the guest room as described in this estimate from the defendant, from Mr. Medina,
Okay.
Mr. Medina Cartagena, and to install the shower door in the master bathroom? How much would it cost you, just in labor? How much would you charge?
Your Honor, I'm looking at probably about 2,500 to finish up what he's got there, just in that bathroom, labor wise. I have it listed down and itemized.
Slow down.
Yes, sir.
All that's left to do is install the shower door in the master bathroom. Do you agree with that?
No, Your Honor.
Did you not agree with that?
I did not.
What do you think needed to be done in the master bathroom?
So the master bathroom, the walls, they're not, it did not smoothen the walls. It did not, at the end of the shower, there's a shelving that needed to be done. He did not do that part. And also he did not raise the vanity and paint it white. And also he took the back wall. You know how you have the vanity that goes, that piece that goes to the wall? He took that off. His guys, when they came, they took that off and they never came to finish. So there's several things that have not been done. And also on the shower.
I want you to say that again. He didn't smooth the walls. You're saying he didn't sand the walls properly before he painted them?
So the walls are not sanded.
Okay,
The shower door is not there.
not installed.
The closet.
Well, you got it. You got the shower door though, right?
Correct.
Okay, shower door not installed. He didn't smooth the walls, so he didn't sand the walls and paint properly is what
Corner
you.
wall, not all the walls, just the corner wall where the metal ends of the shower. It's not all the wall.
Your
Just a
Honor,
little corner.
Your Honor, it is the ceiling. It is the ceiling
Okay,
and the wall, where the, and I don't know how to describe it. There's one wall there. And also the closet has not been done. The floor, the shelves, and the framing of the closet. And also the raising of the vanity and painting that white.
all right. And how much do you figure that would cost for you in labor alone, Mr. McQuithy?
Upwards about $2,500.
Well,
Your
did you
Honor.
give him an invoice? Did you give Mr. Moore?
I did not. I did not.
Did you tell him how much it was gonna charge him? You were
I did.
charge him?
Yes, Your Honor, I did. I did kind of itemize it at home and write down. I took pictures
All these
Um,
things you just heard Mr. Mawarthy mention.
Yes, sir.
Mawathi, I'm sorry. All these things you just heard Mr. Mawathi mention, were they all included in your labor cost?
Yes, Your Honor.
And you're saying it was about $2,500 just for labor?
Yes, Your Honor.
And how much for the labor for the guest room?
The guest room, I know nobody had touched it. I did look at it. He told me they had an agreement on it, and he said that he had figured the guest room work to be about 1,800. Just to do the tile work there and install
Hang
the
on,
door.
slow down.
I would
Do you-
consider
hang
that
on
to
one
be
second.
about correct.
You agree that the price to do the guest room would be about 1,800 just for labor?
That's what.
Yes, Your Honor.
Okay, hang on. And do you agree with him that it would still take $2,500 in labor to complete the work on the master bathroom?
No, sir.
Yes, Your
How much
Honor.
do you- you gotta look at who I'm talking to. Right now, I'm talking to Mr. Medina Cartagena, okay? Just bear with me.
Oh, I apologize.
You said 2,500. You said 1,800 that you think, but that's just what Mr. Mawathi mentioned to do the guest room. I'm asking you, how much do you think it would take in labor to complete the master bath?
So for the shower door, what I charge is $350 to install, just to make the math. Whatever's left, the little paint around that shower that's left, because I left it already mudded and ready to sand and paint, which is a little bit of thin, it's nothing. And just to trim around the closet, that's it. There's nothing about shower vanity or nothing like that. So we're talking about.
Well, you were gonna put up the vanity and
Say-
paint it. Wait. Were you not gonna put the vanity?
No, it's not in that invoice. It's not in there. I gave them an estimate when I was gonna get the basement. When I was gonna get the basement, the 3 bathrooms, and then I told them, I'm gonna adjust something, because you're only gonna give me 2 bathrooms.
All right, hang on a second. Let me double check something, please.
Can I say something, Your Honor?
Not yet. Just let me,
So-
wait. I want everybody to wait. I want to find something I just had in front of me here. Okay, just give me 1 second. This is what he said on the master bath. Demo existing shower and extending 60-inch. Did you do that?
That's what I did.
Add new shower valve, add shampoo box. Did you do that?
It's in there, yeah.
Install shower door. You didn't do that?
That's what it needs to be.
Install 1 light in the shower. Did you do that?
Sir,
Where's anything in here about doing these other things, the painting and smoothing walls and painting the vanity white and
yeah, we're
install?
talking about the shower. We're not talking about the full bathroom. This is a shower renovation, not a bathroom renovation.
Right.
It's 2 different.
Well,
things.
wait, I want you to answer this question.
Yes.
Where does it say it on this invoice that he's gonna do any of these things you just mentioned, other than install the shower door?
On the invoice that you have, I do not have that. There was one that I submitted to court when I was here, and it had my writing on the things that we had talked about that he was gonna do.
He sent you this invoice. It says on September 22nd.
No, he did not send me anything.
You should have, or everybody has it.
But
And it said due October 22nd.
he did not send me anything.
You didn't receive this?
I did not receive all the documents
All-
that he has.
all the-
Wait a minute, let me look at this other thing. Hang on. When I go back to the estimate he gave you on August 20, let's do that on the master bath. Demo existing shower and extending 60-inch. He did that, right?
Yes.
He added a new shower valve and shampoo box, right? Did you install 2 lights or 1 light in the shower?
1 light.
Did you add 2 water supply?
No, it's just 1.
Wait, did you change the exhaust fan and mirror update?
That's not, because the thing is that the first estimate was something I gave him with everything, with the basement and everything. When he decided not to do the basement and the bathroom, I made some adjustment just to get the job, and I told him, okay, so let me fix something for you and give you a good deal on the guest bathroom as well for 1,800. I never charge 1,800 for a full renovation, shower, demoing tiles and all of that. I try to work with him to get those, at least those 2 bathrooms. And then I made some adjustment. Every invoice, every result.
So wait a minute. Do you have a copy of these estimates in front of you? Do me a favor, if you ever come to court here again, send your documents long before 9:30 on the morning of the hearing. There's a discrepancy in the estimate of August the 20th and what you invoiced him for, according to this document. I know you said you didn't receive it on September 22nd. Why?
He should have it because all the receipts that I send him electronically goes through that invoice. So he should receive it.
What in the world's a shampoo box?
It's in the picture. It's a niche. We call it a niche.
Your Honor, if I may say, the backward of the vanity, backwash, they took. If it was not in the agreement, then why did they touch it? All the way from the beginning where the mirror goes, they took all that piece.
Did you?
I didn't touch
Yes.
nothing. The only thing I did was send a countertop guy because he said he wanted to change the countertop. And I sent you a countertop guy. And you say he was charging you too expensive. I sent him a countertop guy because I don't do countertops. And he was gonna give him an estimate for the granite and everything. I don't do countertops. So that's the only thing I've sent him for that.
And in the agreement, Your Honor,
Guys, something changed because in the initial estimate, it had things like install new vanity double sink. Are you
Yeah.
telling me that was in the estimate, but then you
No,
pulled
that
out?
was the estimate, what he wanted before.
You adjusted.
Wanted to change, but then.
Why didn't you send him a new estimate?
He wanted to save
Why don't
money.
you guys, you're gonna have to, this could have been so simple. And I'm sorry, this might not be your forte, but you better make it such because you should have done another estimate. You should have done another
I
estimate. You
did,
didn't
I
do
sent
it,
it to him. That's the last one.
but he didn't invoice you for it. His invoice does not include that.
Now, did he open his estimate, his emails? That's another thing, because I send it to his email. I don't send it by paper. I resend it to him. Once it creates from estimate.
You agree that you owe him at least $1,800 because you didn't do the other bathroom,
I
right?
know that. Yep.
And you agree that you have all of the materials, right?
I have the material.
So he doesn't owe you.
For the material, he does not owe me.
And how much do you figure you gave him for the materials?
I gave him $2,000.
So we agree at least now that he owes you $1,800 at least, and that you keep the materials, right?
$1,500 I paid, yes. I agree with that.
But you keep the materials, so you got your money for those, right?
Yes, and he said he spent $1,700 with the materials.
I'm sorry?
He said at the beginning, he only spent $1,700 with the material.
Yeah.
Of 17 plus the trash removal.
Wait a minute.
That's,
You got the materials. He owes you $1,800 for the guest room, and now we're gonna figure out what he owes you for the master bath.
Correct.
Why is there, I want you both to come up here and I want you to tell me why there is this discrepancy between the estimate and the invoice. Could you stick and this one? This is, yes, you can just say those. This is the documents they just showed me. Small claims cases, always fun.
To their page.
Two below it. I don't mind them. I'm just.
That's fine.
Yes. So why do we have a discrepancy between an estimate that was sent on August 20th and an invoice that was sent on the second stickered page there? I believe that was September, what, 20th? Why do we have this discrepancy between the original estimate and invoice? Because the invoice doesn't mention anything about a vanity. Mentions nothing about a vanity. You guys can back up to the podium. I need you buy a microphone. Why is there that discrepancy?
Your Honor, like I said before, this is an estimate that he wanted at the beginning and then it changed. It's like 2 water supplies, it was gonna be 2 showers. And then he changed, he wanted just 1, so a lot of things changed. So I sent him the new invoice, which was the other.
Well, that's different than an estimate.
Exactly, well, estimates what you want, what are you planning to do for all the work, including the basement, the floor basement.
Why did you touch the walls and do anything along those lines? If there was nothing in that invoice that you indicated you were performing work for? Does that make sense?
How that was it? Sorry.
You said the only thing you did, only had to do.
The master.
Is there a phone going off in here?
It's like there's a horn down the hall.
Okay, thank you. Sounds like, just wait.
Fire alarm.
Oh, thank you. I forgot my train of thought. I'm sorry. Give me 1 second. Something changed in between the estimate and the invoice. He says only, you say he didn't do all these other things.
So also, the 2 water supply, he was raising the vanity. And right now, there's only 1 sink. He was gonna make sure I have 2 sinks. So the 2 water supply, that's where that came from.
But I'm just telling you that he changed on the invoice. The language changed. The language on the invoice says nothing about work on a double vanity. It only has 1 light in the shower.
I personally, when I send the invoice, I'll make sure that's the reason why I like him to sign it. When it's an invoice that we're about to start the job, he doesn't sign, he didn't sign it.
Yeah, but why didn't you ask him?
This is an estimate. This is signed by a pen, not by him, by the invoice.
Yeah, but why didn't you, just future advice.
Yeah, no,
Make
absolutely.
sure your documentation is in order and you get a signed copy that you keep, a hard copy that you keep. For your work. What was that? Jennifer, was that?
I apologize, Your Honor. That was my work phone.
Oh, okay, no problem. How much do you think you owe him? Yeah.
1,800 for the guest bathroom. The shower door, 350, and I'll say roughly finishing that work, about $800 with the shower.
800, including the shower door or an addition?
Doing the shower door, I mean, the rest of the details that he's saying he's not included there. It's a very minor detail, so I'll say like a day work. Now, if he wants to add.
Wait a minute, wait, I just want to make sure I'm understanding you though.
So yeah, 350 for the shower door, and let's say 500 for the rest of the details to finish. To complete what I was supposed to do. Now, if he wants to add the vanity and all that, that's something he's adding. That's not.
No, I'm not adding anything, and also.
Even if he wants to,
Can I-
it's not gonna go to $2,500
Your Honor,
as a contractor, to be honest.
Your Honor, on the top, where he put all the tiles on the top, and he open and
It's called
so
detail.
that will have to be done.
Caulking.
So that will have to be
It
done.
doesn't cost $2,500 for the caulking going around. So
Can you hand me that paperwork back up, gentlemen? Is it just me or do you feel like in retrospect, maybe you jumped the gun a little bit? I've dealt with contractors. Contractors, no disrespect intended, they start other jobs. They start other jobs. We know that they're going to start other jobs. I mean, I knew that 35 years ago, 45 years ago. I'm not saying it's right. But you kind of maybe jumped the gun a little bit and didn't let them finish. By the same token, I'm not sure that you shouldn't have gone back earlier. We told you you had door installed, where do you take a shower? In that room, not the guest room, right?
Take it in the shower, in the guest room. I've never had to shower in this work.
Well, I mean, he's got a master bathroom. That's where you'd like to take your shower, isn't it? So he's waiting. He doesn't have a shower door. Yeah, but
He said it don't work, but it works.
The shower door.
I mean, you put a curtain.
the shower,
But I'm saying it works. He's saying it don't work, but it does work.
I'm saying the apparatus do not work. I'm not gonna take a shower when there's no door. What I'm saying.
Do you have anything else to add, Mr. McQuithy?
Your Honor, the $2,500 included raising the vanity. But I do not have anything else to add. No, Your Honor. And the top of the tile there at the shower, there is about an inch gap. It's a little more than caulking, I believe. A little bit of drywall work on the ceiling there. He did a good job on a lot of the stuff he did. It just looked like he just wasn't able to finish.
Don't you think you kind of kicked him off the project a little early?
Oh, I gave him time.
Well, you didn't really, because you were at September 26th, and I think, based on what I've heard, he said the 29th. I think he spent a week. You said 3 days. I'm comfortable with saying 5 or 6 days. So he didn't finish that work until the 5th or 6th. Wait a minute, just let me finish. And then you ordered the shower door, and you got it a week later. So let's say that you called him on the 11th or 12th, and he's not out there by the 15th, and you're writing him that letter. What date was the date of that letter?
15.
I mean, I don't know.
Because I figured all he would have done at that point, you say, hey, Mike, guess what? I'm not able to do.
Yeah, but nobody likes to be threatened, right? So I can understand. I mean, I'm not going to assign fault on that. He could have been a little more diligent. You could have been more patient. That's my feeling on it. If the shower door was ready to go on the 5th and you hadn't heard anything and you called him several times and he didn't respond to you, I still think the 15th to start sending out threatening letters is a little bit too quick for me. Mr. McQuithy here says it's going to take $2,500. I got to tell you, I truly believe, Mr. Malafi, that you think that you're right. I find you to be credible. I find him to be credible too. He's saying an extra $850 on top of the $1,800, $2,650. I don't see where the invoice. It's clear to me you guys had other discussions after the estimate was done, but before he agreed to perform the work, it was just horribly documented. Everything being told, the $850 plus the I'm sorry, $1,800 plus $850 is $2,650. I'm rounding it off to $3,000. That's what you're going to pay him, and I'm going to hope you're going to pay him today. I hope.
I don't have the full amount.
Well, okay.
But can do it in 2 payments.
Okay, and you have a $70 filing fee, right, sir?
Yeah, but also for serving.
Yeah, I know. I want to ask you about that. How much did you pay for process service?
Maybe it was.
Well, let me double check. Maybe they have it in here. Sometimes on the proof of service. What else, other costs would he have here? Oh, he's got $69.25.
Yes.
Is that right? Were there any other out of pocket?
No.
For the letter.
21 for the letter? Jennifer?
I'm showing he paid the 70 and then the process server.
Okay. Does that sound right to you or not?
It will work. It will work.
So you're gonna get $3,139.25. Now tell me when you can pay him this.
So pay him between this week and next week.
So
Give me like 2 weeks at least. Nothing. I don't know.
how about if I say installments of $1,500 by February the 24th, balance by March.
If I could pay it in full before,
I understand. You strike me as an honest guy too. Both of you do, to tell you the truth. Balance by March 3rd. Can you do that?
absolutely.
I've signed the judgment. I really wish you both well. Good luck to you, sir. Good luck to you.
It's directly to him or?
Yes, yes, you pay directly to him.
Okay.
Does anybody need any of these documents? I don't think you do you? I do want you both to go down the hall and get a copy of the order, though. Thank you.
Appreciate it.
Have a good day. Good luck.
For your time.
Thank you. You're welcome.
Thank you.
Nice to see people leaving a small claims hearing that don't want to throw something at me, right, John? All right.
All right, and let's go on the record in the matter of, where's Miss Tucker? Mr. File up there, please. We're in the matter of Christopher Skelly, 251327. Counsel, your appearance, please. Mr. Westmoreland?
Yes, Your Honor.
All right, your appearance, please, on Mr. Skelly.
I know nothing about this matter, but Attorney Corey Westmoreland appearing on behalf of Mr. Skelvey.
Oh, you haven't spoken to him yet?
I didn't even know this was on the docket.
Then showing at 9 a.m. for probation violation. So we'll recall this matter.
Okay.
So, okay, we'll recall this matter.
All right. Thanks, Judge.
You're welcome. Let's go off the record for a moment.
Yeah,
Where is-
it's not online. It's not. I go based off of that. So
Well, no, it would be, it should, okay, so if you look at 9 a.m., you're not showing Christopher Skelly?
nope.
Interesting. Because it's on our docket and online is supposed to mirror our docket.
One would think.
Well, it's supposed to, so let me see.
Right.
Okay, so if you go back into breakout room 3, I will put Mr. Skelly into breakout room 3.
Perfect. Thank you, Judge.
You're welcome. Okay, let's go on the record in the matter of the State of Michigan versus Jeffrey Biggs Jr., 232366. And your appearance, counsel?
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Jeffrey Biggs Jr., who's present on Zoom.
Thank you. Mr. Biggs, your name for the record, please.
Jeffrey Alvin Biggs Jr.
All right, today is a date scheduled for sentencing in this matter. Counsel, your client has been tethered to treatment. Well, let me just say this. This matter occurred in 2023. And if I recall correctly, your client in 2024 was in Macomb County Jail. And we had arranged your client, set a PCC July 18th of 2024. And the court set a personal bond as your client was serving a sentencing, and I don't have the expected release date written down. Then there are a number of times that we attempted to have Macomb County Jail log in with your client. They did not. At one point, in August of 24, your client was on Zoom, and then the jail logged off. So then we waived your client's presence, set this for an exam. September of 24, preliminary exam was not held, which was the date it was scheduled to be held, because Macomb County Jail would not release your client due to an arraignment pending in 41B District Court. We adjourned this date to an exam. We adjourned the exam to October 3rd of 24. Then October 3rd of 24, a warrant was issued because your client failed to appear, was no longer in Macomb County Jail custody. November 25th, defendant was in custody on the warrant, and that is how we are where we are today. So I just wanted to state for the record the procedural history, because this is a 2023 case and we're just now resolving this.
That is correct, Your Honor.
Okay, and so counsel, did you have an opportunity to review the report and recommendation with your client?
I did, Your Honor.
Okay, and are there any corrections that need to be made?
None.
All right, and counsel, as to the recommendation.
So, Your Honor, I know that when they spoke to Mr. Biggs, he had said that he would rather do county time, but I've spoken to him and it was more so along the lines of he was scared to fail on probation is what, he stated to me. But he's willing, he's been in treatment now almost 2 months. He's bipolar, he's back on, they got him a doctor, he's back on his medication. So his mom has gotten him a place to stay. He's no longer homeless. He's also expressed to me that he's going to therapy in there, and they've shown him some of the destructive habits that he has. And so, Your Honor, I think he was in jail for almost 2 months before he was released to treatment. So I feel like if this court would give him a chance for probation, I think with him being on the right path right now, with him back on his medication, him seeing his doctors, him going to therapy, him having a place to stay, Your Honor, I think he would be successful.
Is your client, in reviewing your client's criminal history, is your client interested in treatment court?
What is treatment court? What is treatment court, ma'am?
Sir, so it's a very, it's a much more intensive probation type program, and you have a lot more one-on-one contact with the team members, and you have your appointments that you need to make, and if with any mental health counseling, you have that as well, depending on which type of treatment court you prefer to participate in. There's drug treatment court, there's mental health treatment court. And so you would then, it's anywhere from 15 to 24 months program. And it would help you get to the root of your addiction issues or help you manage your mental health challenges, sir.
Ma'am, I'll be in Newport, and to get from Newport to Wyandotte is a long walk. I cannot walk that far. So I would have to be like, they would have to be like, I can only get a ride from after 1 o'clock, but they would leave their house at 1 o'clock to get to me. So that's 45 minutes and another 45 minutes. So it'd be like 2:30 by the time I could be there.
Okay, so sir, there is a treatment court in Monroe County that could accept your case if you're eligible after screening for that.
Oh, okay.
If that's something you're interested in, sir, I'm not saying it has to be. I'm just giving you an option.
I would prefer to have regular probation. I don't even know how regular probation works, but I don't want to have extended extra probation if I don't have to.
Okay, well, it's not necessarily extended extra, it's treatment court. But if you're not able to get, if you have transportation limitations, sir, that may be difficult for you to complete probation.
Yes, that was the problem I had in the first place.
Also, given your criminal history and conviction, sir, it doesn't appear as though you're a candidate for probation.
I've never been on probation in my life, so I don't know how that works. But I was on parole. I completed my parole with no problem. I've never been on probation.
Well, I understand, sir. But based upon your criminal history, right, it doesn't appear as though you would be a candidate for probation. Okay. The purpose of probation is to allow individuals the tools to rehabilitate and not reoffend. And you have criminal history dating back to 2011, 2007 also, but I'm not counting that one at this point. You have a felony possession of controlled substance. You have a felony assault with intent to do great bodily harm less than murder. You have attempt misdemeanor, police officer, assaulting, resisting, obstructing. You have using computer to commit a crime. And then you have this matter as well, possession of controlled substance. So based upon all that, sir, it does not appear as though you are a candidate for probation. what the court will do is, the court will the court's going to find that after hearing from counsel, hearing from Mr. Biggs, reviewing the report, the recommendation, the criminal history of Mr. Biggs, that there is not reasonable grounds to depart from MCL 769.5. The court will also note that there does appear to be 2 warrants for Mr. Biggs as well, one of which is out of Clare County. You failed to appear for damage to property. The warrant was dated July of 2025.
Man, I
That's
didn't
the
damage
80th
anyone's property.
That's the 80th District Court. Then there's also another case out of Clare County for disorderly conduct, where you failed to appear on that one as well.
Ma'am, I was wandering around. I don't even know how I got to Clare County. They found me wandering around disoriented. That was
Okay,
that's a
sir.
mental health issue. It wasn't a crime.
Sir, okay, sir, then you need to show up.
I didn't
appear
even
in
know.
court.
I didn't even know I had a
Excuse
court
me.
date. They put me in the mental hospital and then they brought me from the
Sir.
mental hospital home.
Please let me finish.
Okay.
You need to contact the courts when you are released, or perhaps they will have you zoom in from being in custody, or they'll pick you up. I don't know. And then you have your attorney explain that information to them.
Okay.
And so, based upon all that, the court does not find that there's reasonable grounds to depart from MCL 769.5. The court does not find Mr. Biggs is a good candidate for probation. The court is going to order hmm, 180 days jail to be tethered to treatment.
That's 6 months.
Yes, sir, it is. Just one moment. The court will give you credit, sir, for my records show that your client was back in custody November 25th. So I will give your client credit from November 25th.
That is correct, Your Honor.
Staff.
So credit for 78 days. I'll indicate your client is to continue to be tethered to treatment.
June 6th. Get a month off, so May. 2 months in jail.
Suspend fines and costs, including the warrant fee.
So I go back to jail?
No, sir, you can stay in treatment.
For how long?
I'm sorry?
For how long? What day would I get out?
Well, sir, I just ordered 180 days jail with credit for 78 days. You have 102 days left.
I have 102 days left in treatment?
Yes, sir. Well, perhaps the treatment may end up being some other sober living or something. I'm not sure.
Okay, because I only have like to the 18th to be here, and then I have to find another treatment place.
I believe they help you with that, sir.
Can I get the tether off?
No, sir. This is the way to ensure that you're going to be tethered to treatment.
Oh, okay.
Okay.
So I have
Have a good day.
128 more days.
108 more days, sir.
108 more days.
That's what I said.
All right.
102 more. 102 days.
102 more days. Okay.
Yes.
All right. Thank you, ma'am.
Thank you. Have a good day.
You too.
All right. Thank you. Okay. Okay, Mr. Westmoreland, we will go on the record in the matter of Brittany Poole, 251344A.
Attorney Corey Westmoreland appearing on behalf of Ms. Poole. Ms. Poole, would you please state your full name for the record?
Brittany Poole.
Okay, Ms. Poole is on probation for operating while intoxicated. Her original offense of operating while visibly impaired, operating with a high BAC, operating while intoxicated with an occupant under 16, OWI and, not OWI, but the PVT refusal were dismissed by way of resolution between counsel. And so Ms. Poole pled to count number 3, OWI. This was on January 14th is when Ms. Poole was sentenced to probation as well as 10 days jail for a bond violation. And then it's showing that Ms. Poole failed to appear for her instructions on January 28th and also February 3rd, failed to appear for drug testing on February 1st and February 3rd. Counsel?
Yes, Your Honor. I did have an opportunity to speak with Ms. Poole regarding the allegations. At this time, we are prepared to waive any sort of hearing and enter a guilty plea on her behalf.
Ma'am, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, and so, ma'am, you heard the allegations, correct?
Yes.
Yes, those allegations, how do you plead?
Guilty. It's frozen.
And you've gone over you've gone over your advice of rights for probation violation purposes, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You understand the possible penalty as a result of your plea.
I do. Yes.
And that the recommendation in this matter is for probation to be revoked, close the case without improvement, serve 60 days jail. Do you understand that's the recommendation?
Yes.
Knowing all of that, do you want to continue with your plea?
Yeah. Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea today?
No.
And counsel, if you can please vote to your client.
Sure. Ms. Poole, is it true that you're currently on probation out of the Wyandotte District Court?
Yes.
As a term and condition of your probation, are you to attend all scheduled probation meetings?
Yes.
Did you in fact miss a meeting on January 28th of this year?
Yes.
Did you also miss a meeting on February 3rd of this year?
Yes.
As a term and condition of your probation, are you also to drug test at your probation officer's request?
Yeah. Yes.
Did you fail to submit to a test on February 1st of this year?
Yes.
And did you fail to submit to a drug test as ordered on February 3rd of this year?
Yes.
And you understand that those are all violations of your probation, correct?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations, indicate technical violations 1 through 4 will enter. And counsel, as for the recommendation.
Yes, Your Honor. I simply would just be asking for leniency on behalf of Ms. Poole. She currently is looking to go into a inpatient rehab at the Sacred Heart. As you're aware, she's had a very slow start here, but she indicated to me that she never received notice regarding her meetings, and but she is looking to get her life back on track. If she were to be given an opportunity to complete probation, she's going to do everything in her power to do so, as well as take advantage of the programs what this honorable court has to offer. Like I indicated, she's looking to go into inpatient at Sacred Heart, and that's something that she feels very strongly about.
All right, so ma'am, this court ordered probation in this matter, 18 months probation. The court ordered 45 days on the alcohol tether after release from jail on the bond violation. The court also ordered you to report to probation on your next business day upon release. So then that way, ma'am, you could receive your instructions, which you did communicate into probation. Here's what seems to have occurred. On January 28th, you were supposed to have logged in for your probation instructions. On January 28th at 4:36, you sent an email in to the 27th District Court probation stating your name. It says, "Hello, my name is Brittany Poole. I'm writing to receive instructions for my requirements. The website says I would be contacted, and if not within a week, then I need to email." But ma'am, you were notified of your instruction date at 9:45 a.m. sent to your address in Taylor. This email and my phone number are on file, which is this email, and I will include my phone number here as well. And you put your phone number on there. Thank you. Then, on January 29th at 10:04, Ms. Shaw responded to you, "Hello, I received your email and left a voicemail. You were mailed and emailed a notice to appear to probation for January 28th at 9:45 a.m., which you missed. I have changed that to February 3rd at 10:30 a.m., which you missed, ma'am, correct?"
Yes.
Right. So you were on notice. You did have notice of your dates, and yet you chose to not show up. You also, ma'am, were given your instructions for testing, correct?
Yes.
And you did not show up on February 1st nor February 3rd. If you're to test right now, ma'am, what's in your system?
Nothing.
No alcohol?
No. I'm sorry. No.
Okay. And so you've indicated that you are set for inpatient treatment at Sacred Heart. When are you to report, ma'am?
I'm supposed to have a appointment on Thursday for a screening.
Okay. Well, here's what the court counsel finds that Ms. Poole does not seem to be a candidate for probation. This court is going to adopt the recommendation in this matter, given the serious nature of the charges that were originally assessed, and that Ms. Poole had her 4-year-old nephew in the vehicle. She was a .229, and the court does find that the recommendation is appropriate. The court's going to revoke probation, close this case without improvement, order a $50 violation fee, 60 days jail. You're to be tethered to treatment through the Wayne County Jail. That will assist you in your treatment, ma'am. And you are to report tonight.
Okay. Oh, what time?
You're going to have to report no later than 6 p.m., but I'm going to instruct you, ma'am, and order you to email into probation as soon as you are done with this hearing, and they will give you specific instructions.
Okay. I will do that.
Good luck to you, ma'am.
Thank you.
Let's go on the record in the matter of Christopher Skelly, 251327.
Attorney Corey Westmoreland appearing on behalf of Mr. Skelly. Mr. Skelly, would you please unmute yourself and state your full name for the record?
Christopher Skelly.
Okay, today is the date scheduled for probation violation. Mr. Skelly is on probation for a reduced charge of attempt possession controlled substance and controlled substance use. The original charges of possession of controlled substance, one of analogs, one of methamphetamine, were dismissed by way of resolution between counsel. And Mr. Skelly was sentenced on November 24th, 2025. And his attempt possession controlled substance was taken under 7411. And it's alleged now that your client failed to pay, which he agreed to pay $300 per month beginning December 1st, failed to appear for probation appointments twice, and tested positive for alcohol January 12th. Counsel?
Yes, Your Honor. I did have an opportunity to speak with Mr. Skelly regarding the allegations. At this time, we are prepared to enter a guilty plea and waive any sort of contested hearing.
Please raise your hand, sir. You raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
Is that yes?
Yes, Your Honor.
Okay. And you heard the allegations, correct, sir?
Yes, Your Honor.
And as to those allegations, how do you plead?
Take guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes, ma'am.
You also understand, sir, that by entering into a plea, you'll be waiving some of those rights.
Yes, Your Honor.
You understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
And the recommendation in this matter is for you to continue and complete all terms of probation, continue your under advisement status, $50 probation violation fee, 30 days jail suspended, and 30 days on the alcohol tether. Do you understand that's the recommendation?
She said that 30 days jail, because when I talked to her, she told me she didn't recommend jail time. I don't know if that's.
It says suspended.
Oh, okay. Then yeah. Yeah, I understand.
Is that yes?
Yes, Your Honor.
All right. And knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
And counsel, if you can please voir dire your client.
Mr. Skelly, are you currently on probation out of the Wyandotte District Court?
Yes, sir.
As a term and condition of probation, are you to pay all costs and fines as ordered?
Yes, sir.
Did you fail to pay costs and fines in a timely manner?
Yes, but I'm caught up now.
Right. Did you fail to attend a scheduled probation visit on January 26th of this year?
Yes, sir.
And did you fail to attend another scheduled visit on January 28th of this year?
Yes, sir.
And as a term and condition of your probation, are you to not test positive for any drugs or alcohol?
Yes, sir.
Did you, in fact, test positive for alcohol on January 12th of this year?
It did, but then I breathalyzed and it was a 0.0.
Okay. I'm satisfied, Your Honor.
I'm sorry, what about the breathalyzer?
So So I went in and because I work so much, I brush my teeth like in between my jobs, and stuff like that. But that's beyond the fact because I did fail. I went in and I had a mouth urine test or mouth test, and that's what I failed the .024 or 2 whatever. And then on my own will, I did a breathalyzer just to see because I didn't drink. I know I didn't drink.
Okay, hold on.
Yeah, I don't even like to
Hold
drink.
on.
So, but
Pause.
yes, yes.
Okay. You have your own breathalyzer?
No, well, at the testing facility, they have one sitting there with little straws.
All right. Okay, so the court does find the plea is knowing, voluntary, and factually accurate. The court will accept it. Your plea to the probation violation indicate technical violations 1 through 4 will enter. Counsel, as to the probation violation or the recommendation.
Yes, Your Honor. As far as not paying costs and fines, yes, he did not adhere to the payment plan that he had originally set up with accounts receivable. But I believe yesterday you made a $600 payment towards his costs and fines, which is pretty significant. He's taken responsibility for all of his actions, and again, he wasn't consuming alcohol, but he had just brushed his teeth and went into the testing center. I told him, obviously, don't do that next time. So this will not be an issue. He's going to ensure that. So I, at this point, Your Honor, I would just ask. I don't think a tether would be appropriate in this instance. I don't think he was actually drinking or consuming alcohol. I think he just brushed his teeth too prematurely and then walked in to take a test.
Sir, what type of test do you take?
What I don't know, 6-panel mouth test.
You do
Saliva
an oral
test?
swab?
Yes, ma'am.
Okay. And so your toothpaste has alcohol in it?
Well, no, I'm guessing in the mouthwash did, which I've never really been in trouble like this, so I didn't really even put 2 and 2 together and even think about it. I know it's kind of stupid of me, but
Sir, well, I wouldn't say stupid. Maybe a little bit lack of responsibility, since you are given the information, and it even gives you in the instructions regarding your drug testing products to avoid. And that it's your responsibility to look at the ingredients in the products.
yes, yep. I know that now, Your Honor. I'm sorry.
Okay, why did you ghost your probation appointments twice?
So because holidays are really busy at my job. I work for like logistics company. I've been working almost 70 hours a week for the past month. So I'm just really, it slipped my mind between home life and work and my lack of sleep. Yeah, it just totally slipped my mind, and I'm very sorry for that.
Okay, so, all right, so, sir, you have a calendar function on your phone, correct?
Your Honor.
Do you utilize it?
Yes, and yeah, I do.
Did you utilize it for your probation appointments?
No, because I made it while I was driving, and that was stupid of me too. But yes, no, I did not.
Okay, sir, you're not stupid. Okay, so perhaps you want to use that calendar function.
Definitely.
And perhaps if you're on the phone during probation, you want to pull over so that you can enter the information into your device.
Yes, Your Honor. Yep.
All right. The court's going to order you to continue and complete all terms of probation, continue your under advisement status, $50 probation violation fee. The court's going to order 30 days jail suspended. I'm not going to order the alcohol tether at this point. Sir, you can be guaranteed that if you have another violation, specifically one similar to one that you're here for, that you'll be serving those 30 days.
Yes, Your Honor.
You should strongly review all of the ingredients in your items that you use.
Yes, Your Honor. I have since then. Yeah.
Okay. All right, when's your next probation appointment, sir?
I'm supposed to talk to her after I get done with here. So I'm going to give her a call because, yeah.
Okay.
Pursue.
All right, do that now. Have a
I
good
will.
day.
Thank you.
Thank you, Judge.
You're welcome. Thank you.
They're on the wrong side. They're on the wrong side. Come on, counsel. Don't you know?
Sorry.
I know it's your fault, but I'm going to blame them.
By the box.
That's right.
I correct myself.
All right. And on the plaintiff side, who do I have?
I'm sorry, Your Honor.
Your names?
Asim Yassin.
Iris Yassin.
All right. Morning. Oh boy, here we go.
Good morning, Your Honor. I'm Justin Yu. This is my partner, Lazar Georgia. We asked this court permission to appear on behalf of our clients, Mr. Bell and Mr. Jackson, under MCR 8.120 and under the supervision of David Santa Croce
I don't know. Where are you from?
from Seattle.
Seattle. Did I already ask that of you? I may have. You've been before me before, right?
First time.
Yeah. Today's the first time?
Yes, sir.
Yeah. You're from Seattle?
Yes, Your Honor.
It's really damp there.
Yes.
Congratulations on your Seahawks.
I'm actually a Patriots fan, Your Honor.
You are?
Yeah.
I hate you.
Sorry, Your Honor.
Because I am not. The only reason I was rooting for the Seahawks, it was ABTP, anybody but the Patriots. I don't like the. What?
That was a terrible answer.
It was horrible. Horrible. Why are you a Patriots fan?
I was born in Boston, Your Honor.
Oh, well, that's a problem. Okay. So where'd you go to undergrad?
Tufts University in Boston, Your Honor.
In Boston, and then your family's in Seattle.
Yep.
So you came back to Boston and now you're at Michigan.
Yes, sir.
You just can't figure out where you want to be.
Right.
Okay. And what about you?
Yes, Your Honor. I'm from Chicago.
Yay, Midwestern.
Yes, sir.
I love it. Born and bred? Or
I was born in Bulgaria. I moved to Chicago when I was very young with my family.
Bulgaria. Man. Where'd you go to undergrad?
I went to Northwestern in Evanston.
Okay. I have a niece out in Chicago at Loyola. So I'll take it easy on you. So when it gets tough, turn it over to him because I like him better than you being a Patriots fan. All right. All right. Thank you, gentlemen. Permission to practice is granted.
Thank you, Your Honor.
All right. And where are we on this case?
Your Honor, I was served yesterday after I saw the email at 8 o'clock at night where they have a counter claim. So I would like to motion to get a continuance in order for me to be able
To answer the counterclaims?
Yes,
All right.
according to the statute, whatever the court deems
All
appropriate.
right. How much time is it going to take for you to answer the counterclaims?
Well, to answer the counter between 21 and 28 days is what I would like in order to be able to get out the,
No, I probably won't give you quite all that time, but okay.
I'm sorry.
I probably won't give you that long
Okay,
to
well,
file an
the-
answer.
The court deems appropriate, but I will try to do my best.
All right. All right.
Your Honor, we would agree to a month because we have some additional discovery to conduct. We just received this case last week and we don't have all the
Students
documents.
are so cute. We'll agree to a month because we don't care about the court schedule. We just got to go to class. No, go ahead. I'm sorry. Don't mean to
We just
interrupt.
got this case last week, Your Honor, so we don't have all the documents yet, and we discussed with plaintiffs that we would ask for maybe a ledger or any communications or documents relating to any repairs that will be an issue in this case. And this would also give us time to file any FOIA requests to get inspection reports from the city, Your Honor.
So do you have a problem with the month adjournment?
No, Your Honor. That's good.
Nobody cares about my docket. Nobody cares. No, I know. You're saying whatever. They don't do that. They come in just like demanding a month, but they get that from Santa Croce. Just demanding time. All right. Let's do it this way. Do you have a ledger that you can provide them and repair records?
I will provide them with whatever I have, I will provide to them. Yes, I do have a ledger.
Okay,
I have payment ledgers, I have, you know.
okay, but what about documents regarding repairs to the
I would
premises?
have to look them up because there has never been any repairs except for one time, 2-3 years ago, when there was a little water problem. And I had to pay a plumbing company to come and clean up the
line.
line. They did that, and after that, everything has been good. And besides that, repairs, changing of smoke detectors. It's been basically because it's
Okay.
construction and it doesn't need a lot of repairs. Oh, we did change the roof 2 years ago. That was but that was preempted.
So you're going to be able to provide that ledger to them, say, within the next
I
week?
will provide them with everything that they asked me for.
Okay.
And I will also be asking them to provide for a lot of proof because they have a lot of allegations that are out of the air. I'm sorry if I'm talking too much wrong.
All right. No, that's okay. So, well, here's what this is the way the court works without necessarily issuing a formal order for discovery. I expect the parties to cooperate with each other regarding the information. So if you ask them for something, to the extent that they can provide it, if it's there, the obligation is there for you to provide that. Same applies to you.
Yes.
All right. Everybody's understood regarding that. All right. So what I will do then is I will indicate that you're to answer the counterclaims. In this case, you're to do that by February 24th. I'm going to give you 2 weeks to get an answer in on that.
Okay.
Okay.
Question, please.
Yes, sir.
I need them to provide their address because I heard that the address that they gave is not their address, but it's
You need to provide who?
the
Tenants?
the defendants to provide their correct address so that notifications can be made correct.
In terms of the,
Whatever address they want to provide to be notified to.
you mean in terms of your answer?
Yes.
Your answer should be sent to their attorneys. You shouldn't be sending things directly to the defendants.
So we do not need to have their address or anything on record.
Well, why do you need their address at this point?
Okay, the first thing that I was going to do was to send them, which I already probably provided them. They need to provide the address when they move 5 days after they move in order for us to be able to provide them with whatever.
Oh, 4 days, but yeah, go ahead.
And we haven't had that yet from them. So that would, you know, I would, in case anything like that needs to happen. And, but otherwise I would just.
Well, hold on a second. At this point, you're seeking to provide them something.
No, I already did the last time.
Okay, hold it. I'm trying to figure out, why do you need their address right now?
Simply because the law says that I need to have.
They were supposed to supply to you a forwarding address within 4 days of the date of vacating the premises. And their failure to do so has its ramifications if that becomes something involved in this case.
Okay.
So you don't need it. Any communication that you're going to have or make to the defendants in this case, you need to go through their attorneys.
No problem, Your Honor.
All right. So you're to answer by February 24th.
I will.
All right. And then I will adjourn this matter to March 10th, 2026, 9 a.m.
We have one more issue to raise.
Of course you do. Why? Because they're from Michigan. There's always going to be an issue. Go ahead.
Right before this hearing that the property in question is owned by a corporation that plaintiffs own. They own the corporation, which then leases the property to plaintiffs, which plaintiffs then lease to our clients. And under law, they can't represent a corporation. So we're just unclear on the law specifically here. But we just want to raise that to the court.
Well, who is the lease with?
The lease is with plaintiffs. just leased from their corporation.
So well, why would they have to have an attorney and couldn't represent things? Because
they can't represent a corporation if they're not a licensed attorney.
But are they representing the corporation? You're indicating that the corporation leased to them. And
Right.
so,
but the corporation owns the property. So the prior order giving them possession of the property would be to the corporation.
why wouldn't I treat them the same as I would that this really is a sublease? So
You're right.
if I treat it as a sublease, why would they have to get an attorney?
We don't have a clear answer on the law at this moment. We just wanted to raise because it does add some complications or possible complications to this case, Your Honor.
Your Honor, if I may.
Yes, sir.
It seems like a perpetual, it's a wholly owned LLC. And in order to avoid having to retain counsel to represent that LLC, it's some sort of perpetual sublease to themselves individually. And then they lease it. It seems clever at the very least. But I don't know. I mean, it obviates the rule that if you own a piece of property in a corporation and you benefit from owning a corporation, you have to hire an attorney.
Well, except that, I mean, you're right in terms of what you just stated about an LLC and the benefits that an LLC gets. The difficulty is in doing it this way, and the danger for them, while maybe clever in doing it this way, is that any liability is going to attach to them personally. And so that may be a problem.
For tax purposes, LLC doesn't have its own tax return. It's part of the individual return. So the legal identity seems the same. I mean, look, they've been great, but we always prefer to have counsel on the other side. But we just wanted, I've never seen that before, so I just wanted.
I haven't either, and it's probably because the liability issues are probably potentially going to be substantial, and you're probably doing it this way. Frankly, they're going to lose the protection that the LLC has, but that may be their business. Yes, sir.
It's not an LLC, it's an incorporation. It's a C corporation. I
Okay.
live in the apartment where the lady lived. Where she.
Yeah, but sir, here's what okay, you talk over.
I'm sorry.
Go for it.
I'm sorry.
Here's what the issue is, and I don't know that I'm going to necessarily address it today. They've raised it as a potential. Is that it doesn't matter what type of corporate entity owns the premises. That corporation has leased to you.
Yes.
Okay. I think you need to understand that should they prevail on some issues, the liability for some of this goes directly to you. The corporation is not a protection from it. There may also be issues, and maybe this is what they're getting at. There may also be issues of if it is a circumstance where the corporation isn't really there, that it's just there in name, but you guys are operating, then they're going to go behind that corporation if they needed to get at the property. So
I understand that.
Okay.
Corporation is legal, everything is up to date. And
yeah, but so let me put it this way, and I'm not saying that it is, but if it were a situation that the corporate entity is really nothing more than a sham that can create other problems for you.
I understand, Your Honor.
Well, I hope you do. I don't know if we'll get there. Pardon?
It's an interpreting corporation which owns the premises, and it works with the courts. I provide interpretation for the court. I'm a qualified interpreter, so the corporation is good, Your Honor. So I have no problems.
Well, it may be for some purposes and maybe not for others. Yeah, I'm going to suggest to you, sir, this having been raised, because I don't think you understand what I'm saying. I'm being very careful in what I say, that you may want to get some legal advice, because I can see where it may potentially cause some problems. Anything else?
That's it, Your Honor.
You sure?
Yeah.
You sure, Seattle?
Yes, sir, Your Honor.
He's a patriot. He's a patriot. You know what? I should take him. I should have you take him in. See? No. He didn't know what to do. He's like, oh my God.
One more question, Your Honor.
Yes.
You gave me 14 days, but if you give me 21, since they are asking for a month, that way I can have a little more time to provide them with whatever they are asking me to get.
I need an answer by then. I'm not saying that I need all of the documents.
Oh, okay, I'm answering.
I mean,
even purpose to, if anything comes up, I can add it to the answer. Is that correct, Your Honor?
I'm not going to say it that way. You need to answer their counterclaims by that point. The providing of documents and other information between the parties is something that is going to continue throughout. So you get the 2 weeks. You can provide an answer to this in 2 weeks. I'll see you guys in 30 days.
Okay, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you.
Have it write it in Bulgarian. Just what? Just see if he can, because I don't know if he's telling me the truth. I just don't know. Just saying.
I'm impressed. I didn't realize you read Bulgarian.
I do. I'm fluent. Yeah.
So much.
That's peace. Thank you, guys. Take care. What is this last?
Requires a mandatory interpreter.
Requires a what?
Mandatory.
No, it doesn't. That.
Is present, but I don't believe tenants are.
Wait, what is this on for?
They are not paying.
Okay, he's gonna. Sanford versus Norman.
Norman's in Zoom, you're on.
Oh, there she is.
Good morning.
Gil Stanford.
All right. Miss Norman, can you state your name?
Susie Norman.
Okay. And that's a wrong screen. No, that's okay. I'm good. I'm good. I'm good. All right. Where are we on this case, folks?
At the last hearing, we were reading on the evidences I sent. One was a flash drive.
Yes.
Due to the weather and the courts being closed, it hadn't been logged yet.
Correct. I think
also,
we have it now.
Yes. And I believe that your coordinator helped Mr. Stanford to play his flash drive.
Right. Did you get all the stuff off of the flash drive?
I did see the video of the previous hearing on that, yes.
Okay. And so with reference to that previous hearing, you have something you're holding up. What are you trying to do?
I submitted to the court an answer to that, and I sent a copy to her. I don't know if she's received it or not yet.
Is that the response to defendant's objections and evidence submitted about January 15th, 2024 hearing? That's what you, okay.
That's right.
All right. Have you received that?
I have not.
Okay, folks. All right. All right. Somewhere along the line, we've got to make sure, because it becomes impossible for me to conduct a hearing where one party has submitted something and the other party doesn't have it. And I'm not saying, I'm not blaming either party. I'm just saying that's the cold-hearted reality of where I end up.
Your Honor, may I say
How did you send this to Miss Norman?
U.S. mail.
Okay, well,
You know, and
that's gonna be.
I thought our hearing was a little later in the month. I thought she was going to get it, and I just got the notice about our hearing date yesterday. So I was thinking maybe I should.
Well, that maybe should tell you something about the mail. All right. Here's what I'm going to do. I think we have Miss Norman's email, right?
Yes, sir.
Okay. So folks are not sure that, yes,
Can I
ma'am.
say something, please?
Yes, go ahead.
That video from the hearing from 10/22 of 2024 has on there where Mr. Stanford waived his right to monetary damage and rent because of the case, and my case being I dismissed my case in order to come to that end. So I don't know. I just feel like at this point, it's, we're just on the court's time and we're wasting it with,
Well,
all of these things.
Ms.
It's just-
Norman, I understand what your position may be. My position is that if somebody submits something to the court, I have to at least look at it and consider it. The very fact, I don't think, if you think about the last hearing, you submitted something and I didn't get it because of whatever the circumstances were. I didn't have it. I don't think you would want me to proceed without having that. Mr. Stanford has submitted something. I'm not going to have a problem going through it. You just have to have it so that you can respond to it if necessary, because you're entitled to have it. Here's what I'm going to do. At this point, there'll be no additional filings. All right, because I don't want to end up in this circumstance. We have Ms. Norman's email.
Yes, sir.
All right. So what I'm going to do to expedite the process, Ms. Norman, because normally I'd put it out however long it may take the mail to get there. I'm going to have my staff copy what Mr. Stanford has submitted, email it to you so that you have it. Okay? And then.
So what
my
happens
next-
then? He's got an answer to the video, and then I see something on his answer, but yet I can't answer.
Then you guys can argue that before me. Ms. Norman, I can't force this to go any different.
I don't want
If
to
I could-
argue. I want it to end. I want it to end. And this is just how we were in October of 2024. Frustrating you.
So I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
permit the court to
I'm not a
proceed
failure.
with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Ms. Norman? What did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case. He has,
Norman, I'm
I'm
going to
just-
tell you this, and then I'm not hearing anything else from you. I'm going to do what I got to do.
That's fine.
I'm just
That's
going to,
fine.
no, do not talk. Stop.
I said I won't say anything else.
Stop. Just stop.
That's how you treated me in October of 2024 as well.
I'm done. Then here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep, we'll just put it out so she can get the mail. I'm gonna do it that way. I was trying to expedite it for her, but she's gonna treat me rudely. It's not gonna happen that way. Give me a date. I'm done. Mute her, because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th, 2026, 9 a.m. Thank you. You can kick her out.
Well, should I do something crazy, you think? Like this? Oh my. What is this? This is me scanning through a docket I have not even watched. What was her name? Norman?
To charge rent is now my
Now,
Oh, Eureka. You've got to be kidding me right now.
So that opened, it's supposed to go under,
How crazy is that, right? Welcome to October 22nd of 2024. The date the lady was just talking about. We're getting ready for a hearing. They seem to be in person. I have no clue what is in store for us, how long it is.
14A District Court of County, Washington.
Oh my God, this is a long docket, so we'll see it. We'll check it out together.
And where's my officer? Here he is.
Your Honor, good morning.
Randy, come on out. How you doing?
Well, how are you?
Not too bad. Now raise your right hand. Do you solemnly swear or affirm the information contained in the search warrant and affidavit are true to the best knowledge, information, and belief?
I do.
All right, Randy.
Wait, this doesn't sound like the case we're looking for. I'm scanning forward. Scanning forward.
Is that the first one? That's up. Okay, gotcha. One's my line. Did you not get a response from Alex office?
Can we call the case we're looking for?
Communication with them, but I believe we picked the state specifically because of the Tuesday she had a child.
I don't know.
I can.
Did we send an email?
Yeah, yeah, an initial one. Yeah, but I've not.
Oh, you didn't email it?
No, I haven't.
Okay.
But I will.
All right. Okay. Stanford versus Norman.
David Brodsky, thank you so much for that. I do appreciate it.
Morning.
Oh my.
Morning. Morning, Your Honor. Jim Kurji, PA 320 on behalf of the plaintiff, Gil Sanford.
Your name?
Susie Norman.
All right. And where are we on this case? Well, good.
So, Your Honor, I submitted a motion for summary disposition. And that there's no genuine issue back here on this non-payment.
Did you get a copy?
I did, via email.
Are you going to respond to that?
I have, my response was a case that I had opened. It's supposed to go under Judge Barr.
That was my response. And I came to the courthouse and wanted to file what I could. And the girl said there was a note on my case that said, Judge Barr, I guess Judge Barr, I don't know. Someone wrote a note that you were going to look at that today and use that as my
Okay, right.
counter,
Well,
since the cases were of the same people.
have you vacated the premises or no?
I have not. As you know, I have my job offer in Seattle, and I'm here because I'm still here in the city because I have to appear in person. So, and just trying to wrap this up.
So in regard to your motion for summary, why wouldn't I consider what she has filed in the other case as creating a genuine issue of material fact?
So Your Honor, one moment. The jumps to that case is that her property didn't have a certificate of occupancy. That was just brought to light recently as, I guess, a separate claim. Rent was ordered to be placed on escrow by the court. Rent has not been, only 1 month of 3 months rent has been placed on escrow with the court. My motion.
Right, but if there's no if there's no COC, how does your client even charge rent?
So Your Honor, my client has been in touch with the city of Pittsfield and has been arranging to get the COC.
The city of Ipsy?
Pittsfield Township.
Yep, okay, that's fine, but how does he charge rent if he doesn't have a COC?
So Your Honor, this is not a, we're not claiming rent. We're not claiming money damages for rent. We're just claiming for the possession.
I don't know what that means.
This is not a claim for money damages. It's just a claim to return the property. At some point, some rent is due because Ms. Norman remains in possession of the property.
But there's no COC.
Your Honor, the COC expired in March of this year. According to the city of Pittsfield, according to my client, the city of Pittsfield has told him they are shorthanded on building inspectors. That's why he didn't receive a notice. He's been in touch with them to try and get the COC sorted out. The number of things pointed out on the violations of the other case are things such as a permit for electrical outlets, permit for a water heater. There's no complaints in that inspection report of items that are not working. It's items that are not up to code.
Is there anything under the Pittsfield ordinance that extends it?
Say again.
Is there anything under the Pittsfield ordinance that extends the COC?
Not that I'm aware of.
There isn't.
But I have no control over them administering their duties as far as issuing those.
Do you have the counsel? Do you have the prior COC?
I don't, but I don't have it on me, Your Honor. But it was issued in 22.
With CFO?
Yeah. My client might have it on.
Give me a minute here to get down.
You have a seat, Mayor.
I can.
Did you call to get an inspection?
I called the building department in regards to this matter. And they.
No, prior to March.
No, I did not, because I was not aware that this was about to expire. Normally that process is.
It's a 2-year certificate.
they send out letters saying,
Right, I understand that, but it's a 2-year certificate. So the question is, if she's paid rent through June,
Last payment was on 5/24. And I have a balance on the property of to the best estimate, $19,845 in rent and $1,500 in water bills and other utilities.
19,000?
In rent due. Rent's $3,300. I have the last payment on 5/24 of $2,230. $1,230. If you would like, I have a ledger based on the payments that were submitted in her other case.
Okay, but you have to get past the legal issue of how can if his certificate of compliance is expired, how does he charge rent?
Your Honor, so I believe that the rent being questioned would be the rent moving forward from the time in which that was brought to our attention. But that's correct, Your Honor.
From the time it's brought to your attention.
Yeah, from the time the issue's raised.
Pardon?
From the time the issue's raised, Your Honor. She signed the lease. She's made payments as if she were, as if there were a COC. Turns out there's no COC. We're not asking for.
From May through today. How do you charge rent if there's no COC?
I believe my client's in a position where he can't charge rent or that rent would be disputed.
That what?
That rent would be disputed and it's being disputed in the other case she's raised.
Right.
Right.
I don't understand what you're saying. You filed a landlord-tenant case seeking non-payment of rent. Right?
Seeking possession of the property for now.
Seeking non-payment of rent. Right?
Correct, John.
You can't, under what theory can your client charge rent if he has no certificate of compliance?
Your Honor, I don't have a theory right now as to a legal theory as to how we can do that. I have,
well, then how are you going to go forth on this case?
the other option, Your Honor, is to do.
We would all agree that in order to charge rent or to rent property in Pittsfield, you have to have a certificate of compliance, right? We're all in agreement on that. He has no certificate of compliance. So how does he charge rent?
So, Your Honor, I think the answer would be that he can't charge rent until he gets a certificate of compliance. Or see.
Okay. So it expired in March. The rent you're claiming she owes is for a period after March through today. And from that period after March into today, he doesn't have a certificate of compliance. So how does one evict?
So, Your Honor, we could go through with a 30-day notice, but my client has been undergoing efforts to obtain that COC. It's not as if he has just ignored the issue. He's made efforts to correct it, and he would like to correct it. The problem with correcting it right now is that Ms. Norman is in possession of the property, and he can't make repairs or has attempted to make repairs and been told.
Has he attempted to make repairs?
That is.
I have tried to make repairs. There's been 4 times when I have sent a 5 minutes to go over there, make repairs, and she has refused me to enter to make those repairs. So I can't make the repairs.
When is the township going over?
What's that?
When is the township coming in to inspect?
Well, they are claiming that they're come back in November 2nd or something. But
Then counsel, if that's the case, why am I hearing this now? You have no legal theory upon which you can proceed. The other case is now my case. So I'm just going to consider it as a counter to this case. So why am I hearing it today if your client has no COC?
Your Honor, I heard it first at the last hearing, so I may have a moment to confer with my client.
This is why Ann gets on. So much. I never felt like that. Way. That's what people are allowing was stuff. Right.
Thank you, Your Honor. We can agree to dismiss this at this time and move forward with under a different process as my client attempts to obtain a COC. The court feels that that's the best thing to do at this time.
I'm just trying to figure out how you're going to proceed. I think part of Ms. Norman's claim is that she's owed money.
So Ms. Norman has been in possession of the property the whole time under a lease agreement. Now that lease agreement has an issue with the COC.
She cannot legally do because he doesn't have a COC.
So without more investigation into the COC and why that wasn't issued or what the issues are with the COC, I can't speak to the matter at this time. I've looked at the inspection report that was provided in the other case, and the items on the inspection report didn't appear to be items that would be interfering with the daily use of the premises.
You do understand this isn't about habitability.
Correct, Your Honor. My client has, if you had some difficulty obtaining.
What's that?
You had some difficulty obtaining COC for.
This probably was.
Yeah.
Well, they made an inspection and made this report, and they have another inspection lined up for the November 2nd. But if she won't let me go in to make repairs, I told the building department, because we're in the middle of an eviction, that I want to delay that till she lets me in. Will you make an order to?
Your Honor, I think he's saying until he believed he would get possession back and then finish the permitting of the boiler and whatever was on the inspection report.
When are you going to let him in?
The problem with me letting him in, the first time, he comes over unannounced, and I've asked him not to do that. I've asked him to contact.
Okay, Ms. Norman, give me a date that you're going to let him in.
He give you a date when he could come in and repair, or when? I'm sorry, I didn't hear you. My bad.
Isn't that what I said?
Is that what you said?
Yes. That's what I said.
I don't have a problem with him coming in. I have a problem with him cornering me off asking me when I'm getting out of there when this case is ongoing. He's done that twice. That's why I have a police report on my other case, because he just popped up unannounced, asking me when I'm gonna pay the rent, flashing the water bill. I talk to Cindy at the Pittsfield Township every time we have a court date, and he has me paying it. He's suing me for the water bill. I just let them know that I will, if whatever the ruling is, I will let them know if I have to pay it or if I have to pay him and he's gonna pay it. I don't have, so that's the only problem. He comes unannounced and he starts asking me when I'm paying the rent, when I'm putting stuff in escrow, when I'm doing this, when I'm doing that, and that makes me feel uncomfortable. So if he needs, and I know that the city has had, he said that they were backed up and couldn't come. I called them and they came for me to inspect it.
Okay. So I don't know why neither of you want to answer my question.
As I don't have a problem with him coming and doing his repairs, if that's what.
So what day can he come in?
Whatever. I mean, he can give me a day. He's all over like we've done this before, and it's like, you have to ask him. I will make it.
Okay, so what day do you want to go do the repairs?
I cannot say that it's gonna be all in one day. There are several.
Okay, so what day do you want to start doing the repairs?
I will start later this week. I will come in Thursday or Friday. Either that.
Emily, if I said to you, give me a date for a case, would you just give me any date and just an approximation? No, because that's not what I asked, right? Yeah. So glad we got it straight, because I was trying to figure out if that's how it worked. Yes, you.
I will do the work next week. Between Monday and Friday, I will.
So what date are you going to, geez, oh, Pete? Just
Monday.
What is Monday, Emily?
The 28th.
28th.
But I will also, if I need to be in there other days. There's drywall repair that needs to be done. That cannot be done in one trip. I need to have inspectors lined up and scheduled to come in for their process. And I don't know what their schedule is and when I can get an inspection for them. It's not a one-day repair to get these things done.
Oh, no, I've seen the pictures. I realized it was going to be more than a day. So you're going to go in, start repairs on the 28th. Question mark, right?
Monday the 28th. I will plan on going in and doing all the repairs I can that day. There will be other issues that still need to be addressed with
you guys.
With the building department.
Okay.
Sorry.
When are you leaving? That was also a question.
I am leaving as soon as I don't have to come back to court anymore. I mean, can we do it in Zoom in Seattle? I just can't move from there to another spot and then to Seattle. The only reason I'm still here is because this case is still going. And the reason I'm here is
okay.
Seeing the pictures.
So,
I mean, is this case going to be done after today? Is it going to be completed, finished?
At the rate you guys are going? Really? Hey, so here's what I'm gonna suggest. Can you guys talk to each other civilly? Without me?
I certainly think I can.
Your Honor. This case resolves itself with possession.
What?
This case resolves itself with possession. Should Miss Norman be moving to, or going to Seattle?
Except counsel. You're charging rent. You just told me it was 19,000 that you want from her.
Your Honor, what we want is possession. We haven't claimed, there's been no claim for money judgment.
So you're gonna waive rent?
No.
Okay.
Well, in this case, we're not asking for rent.
Wait.
Wait.
Your Honor, my client agrees to waive rent.
Okay, well, would you agree to release the escrow to me so he can get possession? I can go and the case can be done today.
Wow.
As much as I like to be in this courtroom, this is my eighth.
Oh, I liked it until this morning.
What?
Look, here's what we're gonna do. You're waiving rent. You're waiving any claim for monetary damages.
Yeah.
Is that right?
Yes.
And when are you gonna leave?
10 days or less.
Perfect.
Mr. Kurji said perfect. I'm not trying to stress you out, Judge.
You are not stressing me out.
Okay,
Trust
good,
me.
Good.
Trust me, I got a lot more. I got a lot
Okay.
of other things that stress me out. This is not one of them.
There's the bright spot.
Okay, so what are we doing? You waived your claim for rent. You're moving when?
10 days or less, and I can take the keys.
So Pete, give me a date. Just give me a date that you're going to leave.
What is the date today? The 22nd? October 31st.
It was the 22nd. It's probably the 25th by now.
October 30th.
What? October 30th. Will that work?
That worked, Your Honor.
Do I need to get this repairs done next week? Or that's, can be done after she moves out?
Write up a conditional order of dismissal, waiving all claims for rent money. You can put both case numbers on it because if there's no claims for money, then that would resolve your other case, would it not? Amazing how I do this. Write up a conditional order of dismissal, look it over. She's going to leave on the 30th. And then come back and I'll sign it. All right, I'll pass the matter so you can write that up.
All right, thank you.
Come back today.
Today. Oh, no, you guys are not leaving.
In escrow.
What about it?
I'd like to have that.
Okay, if they've waived all claims for money, what do you think happens to escrow?
I don't assume anything. In nursing, we don't assume it. I can't assume it in your courtroom, sir. As long as it's written on the conditional dismissal, then fine. Can't assume anything. I don't know the law language. I don't know it.
Oh, I'm aware.
I know.
I'm aware.
The 8 times I've been here.
What?
I said, I know you probably gathered that the 8 times I've been here.
It's only been 8. Seems like 50. All right. Go out, write that up. Escrow goes back to defendant, plaintiff on the other case, and then we can be done with this.
All right, thank you, Your Honor.
Thank you. Hey, do me a favor. Keep an eye on them because that's going to blow up. I don't know what's going to happen, but it's going to blow up.
Okay. So there's a long blank section that happens.
I want to call another one. I know. It's going to go better. Well,
I'm not sure.
Court does call the case of Finney versus Sidoni.
Okay, we're not watching this one. We're not watching this one. We're gonna scrub. We're scrubbing. Scrubbing. We're scrubbing. Okay. Here's the long blank section. Whoop, 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 whoop.
Judge Day said extension presiding.
Okay. And here we are.
The District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Day said extension presiding.
You may be seated. You guys work out. Let's try it again for the third time. Stanford versus Norman.
Norman and I have, we've come to a clarification on the consent order. Plaintiff is going to waive any claim to rent. Defendant agrees to return possession on or before the 31st of October, 2024. Plaintiff and defendant agreed to split $3,300 escrow in the following way. Plaintiff is to receive $1,500, the defendant is to receive $1,800.
Plaintiff gets $1,500.
Defendant shall receive $1,800.
Did you write that up? Norman, is this your understanding?
Yes, it is.
Do you have any questions regarding anything contained on this conditional order dismissal?
I don't have any questions regarding that. I do feel like I'll be back to see you though. For
Why?
damages, but
For damages.
yeah. But
Underlying which in,
I understand that and I signed it and there it is.
well, but that's going to get rid of this case also. That's why I had you put both case numbers on. I was trying to resolve all these cases. So is that your understanding, ma'am?
Yes.
Just going to add a provision on here that case ending in 3728 is dismissed as part of this. Do you have any other questions regarding anything contained on this? All right, you do have 3 business days to think about this. If you have any, if there's any legal reason, any misunderstanding, any non-assertion of rights in this matter, you'd have to file a motion with the court. That doesn't mean that I would grant the motion. However, you do have those 3 business days. You understand that, ma'am?
I do.
Case ending in 2445 is conditionally dismissed, and I've signed the order. You can pick up a copy up front. The other matter is dismissed. Thank you.
Thank you, Your Honor. Good morning.
Okay. Earlier I said this was a legendary docket. I'll show you why. I'm going to hit pause real quick. And I'm just jumping forward just a wee little bit, and I'm getting out of the way. This guy.
with my answer or brought up in the trial, negate those accusations properly.
This was a legendary case. My Lord. I'm not playing it. I'm not playing it. We may revisit it at some point in time, but oh my Lord, was that a legendary case. He should look familiar. He was, I think he was drunk during this appearance. He's pretty much a squatter. Refused to pay his bills. It was a whole thing. But that being said, we're going to back things up right here just a little bit. And we're going to remind ourselves why we just spent the last 55 minutes watching that little piece of Judge Simpson just relive this little bit of goodness right here. Let me get this stuff off the screen. There we go. Oh yeah.
Tell you, Miss Norman. But what did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case.
Miss Norman, I'm going to tell you this, and then I'm not hearing anything else from you. I'm going to do what I'm going to do.
That's fine.
I'm just going to, no, do not talk. Stop.
I said I won't say anything else.
Stop. Just stop.
That's how you treated me in October of 2024 as well.
I'm done. Then here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep. We'll just put it out so she can get the mail. I'm going to do it that way. I was trying to expedite it for her, but she's going to treat me rudely. It's not going to happen that way. Rudely. Give me a date. Respectful. I'm done. Mute her because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th, 2026, 9 a.m. Thank you. You can kick her out.
And that gets us back to where we were before we took the trip down memory lane to October 22nd, 2024 to see Miss Norman's previous appearance with Judge Middleton. And yeah, I have to be called out. I said that was 55 minutes. Rhonda, you're right. I didn't realize there was a bunch of stuff. It was more like 25 minutes, wasn't it? Hey, we did pretty good, actually. It wasn't all that bad. But these are the crazy things we get to do when we're live like this. I've had a lot of fun. I do want to say thank you so very much, David Brodsky and Rhonda. You are both wonderful, wonderful individuals. And I do want to say thank you from the bottom of my heart. I greatly appreciate you. The puppies are asleep and they greatly appreciate you, I assure you. The cat, he's back there someplace. He doesn't care one way or the other. He just wants his little piece when he can get it. That's a cat for you. But we love them all the same. Ladies and gentlemen, I am your Lone Wolf Usul. I am your host for these here videos, your curator for this here channel at Court Gallery. I want to invite you to come by every single night around 8 p.m. Central Time, 9 p.m. Eastern Time. I do all these things where we watch daily court videos from the day. And on the weekends, we compile a bunch of them from the previous week and see what was going on. Sometimes we even go long and watch stuff from the deep archives when I realize that I actually have it. That's what we did tonight. So thank you, ladies and gentlemen. Thank you all for coming by. And come on by, same wolf time, same wolf channel tomorrow, every day afterwards for more court goodness right here at the Court Gallery. For now, I'm just going to say thank you one more time and remind you, I'm your lone wolf Usul, and I am out. I think I fixed my mic issues too. I was rewatching some of the previous episodes, and I really think my mic sounded horrible. I did a lot of work on it today. Do you think it sounded better, Marty, Mama? I think it's better now. There for a while, I was actually chasing Mike for having the worst mic. I said it. Oh, it's no better. You can still hear me. I am sorry. I'm sorry. I should fix it. I should fix it to where you can't hear me anymore. Then things will be much more improved. Ha ha ha. Don't come here looking for Ferris Bueller references. That's not what we do around here. We watch court. That's all we do. We're done. Go. Scoot. Get out. Got no more. Well, I do. I've got plenty more, but we're not watching it right now. Come back for later. Come back later for more. Next time. Oh my God, I can't talk. Bye.